If you've just been arrested for domestic violence in California and you're scared about what this could mean for your job, your record, or your future, this video is for you. Now, you might feel like you have a defense, or you might be wondering, based on the situation, what your defense even is. In this video, I'm going to walk you through 6 of the most common real-life situations I see as a domestic violence defense attorney and show you how, with the right legal strategy, the facts of your case, what happened to you, could be shaped into a defense that actually works in court. My name is Veronica. I'm a domestic violence criminal defense attorney, and I help people across California put their cases behind them so that they can move forward with their lives. Every case is different, but for the clients who hired me and whose cases were resolved last year, 75% had their charges dropped entirely, and over 95% avoided a conviction. It's not luck. That is strategy. So let's get into shaping and strategizing a defense, starting with number 1. They hit me first. It was self-defense. This is one of the most common things that people say, and it's completely understandable. If the other person started it, how are you the one being charged? But in California, self-defense isn't just about who hit first. It's about whether you reasonably believed you were in immediate danger and whether the force that you used to protect yourself against that danger was proportional to the threat. For example, imagine that you and your partner were arguing in the kitchen. They slapped you and you shoved them. Now that can look measured and defensive, but whether that actually is self-defense turns on basically whether you thought that they were going to hit you again, and that is why you shoved them. It cannot be retaliation. Now, what your lawyer needs to show is that you were protecting yourself, you were not lashing out. Using this defense is going to require showing that you thought that they were going to slap you again or take some other action, and the only reason that you shoved them was to stop them from doing that. Number 2, they were blocking my path and I was just trying to get past them. This happens in domestic violence cases a lot. You're trying to leave the situation and they are standing in the way. Let's say you and your girlfriend were in a small apartment with a narrow hallway. You try to walk past her to exit and your shoulders bump. Now, generally, this is going to be in the context of a heated argument, sometimes a breakup where you were just trying to get yourself out of the situation, basically exactly what you probably should do. She calls the police and you get arrested. Now, even small physical contact like that, like bumping into someone in a hallway, can be charged as domestic battery if it is not explained properly. What your lawyer needs to show is that you were just trying to get through a tight space. You were not trying to make any contact with them, and any contact was basically just incidental. Your goal was not to touch them in any way. In fact, you tried to avoid touching them. Perhaps they moved, and that's the reason that the two of you collided. Now, a photograph or even a basic diagram of the apartment can help clarify your intent. Not to escalate, but to walk away, especially if that was your only path of exit. Number 3, they've been abusive before and I just snapped. Now, this is something also that I unfortunately hear a lot, and it makes sense emotionally and maybe morally and logically. When someone has mistreated you, abused you for months or years, it is human to reach a breaking point. But the law doesn't generally recognize I snapped as a defense in a domestic violence case. You can't respond to past abuse with new violence. But the key is showing that your fear, not your frustration, drove your reaction based on their past behavior. So basically, your defense here would be self-defense. Let's say that your fiance had a history of hitting you, and one night he charged at you during an argument. You reacted by throwing a vase at him and hitting him. Now, if the defense is, I couldn't take it anymore, that's not going to work. But if your lawyer can present evidence, prior messages, threatening behavior, past reports, then it becomes about what you believed was about to happen, which is crucial for self-defense. When they charged at you, you thought what was going to happen, what probably was going to happen, is what happened all of the other times. And that is what you were trying to stop. And that is what turns a reaction into a legal defense. Number 4, they're unstable. They drink, lie, they've cheated on me. Who's going to believe them? Now, if this is your situation, you may be thinking, how is their word going to be taken seriously? They're always lying. They were drunk. They've cheated on me before, and I have evidence. But in court, attacking someone's character in domestic violence cases usually backfires. Sometimes it can be used as a motive for you to have committed self-defense by the prosecution. What matters isn't necessarily who they are, it's what they said about this particular situation and whether that story holds up. If your partner's a liar, let's catch them in their lies. If they were drunk, how can they remember what happened? Well, let's say your partner gave one version to the police, a different one to a friend, and something else entirely in a written statement. What your lawyer needs to do is point out those inconsistencies and those contradictions. That is called impeaching credibility, and it is a powerful tool when it is your word against somebody else's. It's not about saying that they're a bad person, even if they are. It's about showing that their story doesn't add up and that their story, their word, is not good enough for you to be convicted based on it. Number 5, they told the cops that they didn't want me arrested. Now, a lot of people breathe a sigh of relief when they hear that their partner said that they did not want to press charges. They think, even though I got arrested anyway, I shouldn't have. It was all a big misunderstanding that will be cleared up, right? Not necessarily. In California, the decision to prosecute is up to the district attorney, the prosecution, not the alleged victim. The same way that even though the victim maybe didn't want you arrested, the police got to make a decision and they chose to arrest you anyway. Now, if the other person does not want prosecution, that information can still help if it is handled carefully. Let's say that you and your spouse got into a heated argument. They called 911, but later said that they did not want you arrested. Before they make any more statements or attempt to help anymore, you need to hear what is on the 911 call. What did they say then? Because if they keep making more statements and they are inconsistent, it can look like they are being pressured, that you're manipulating them, and that is usually what the prosecution will argue. What ultimately is going to be important is that they explain, if they made statements saying that you were committing domestic violence, that they explain why they would say that if it wasn't true. Number 6, there's no evidence, it's just their word against mine. This is something I also hear all of the time. They can't prove anything. It's just their story against mine. It's just a he said, she said. But under California law, a single accusation, even if they take it back, can be enough to file charges. If they are believed, it can be enough to convict you ultimately. So instead of focusing on there's no evidence or thinking that the prosecution's case is automatically weak because it's a he said, she said, it's often more effective to expose what's missing. So let's say that your partner said that you hit them, but there are no photos of bruises, no medical records, no witnesses, and the timeline that they've given does not make sense. What your lawyer needs to do is go point by point, showing what does not match, what wasn't documented, and what was left out. Basically, when I'm doing this, I go back and I think, okay, if I were in the alleged victim's position and their story is true, what evidence would exist? Does that evidence exist or not? Because if it doesn't, then that is exactly what I need to point out. If I was telling the truth and all of that really happened to me, then why has my story changed if it's changed in important ways? Now that's where reasonable doubt comes from. Not just denial, but dismantling. Okay, so those are 6 common situations that I see as a domestic violence criminal defense attorney all of the time, and the defenses that go with them. If you work in healthcare, education, tech, finance, anywhere that requires a background check, professional license, or public trust, a domestic violence charge could affect everything. A conviction in California, a lot of people don't know this, can never be erased from your record. That is why it is critical that you have a strong defense strategy. One that's not just about reducing the charges, but no, one that is about protecting your career, your reputation, and your future. I hope that this video helped you. If you have been arrested for domestic violence in California, feel free to reach out. You can find a Calendly link to book a free consultation down below. You can also find our phone number there. Look, you don't have to have it all figured out. You don't need a perfect story. You need someone who will listen and help you start building a strategy that protects your future. If this video did help you, please don't forget to like, subscribe, ring the bell. And if you have a question or a comment, leave it in the comments.